Hi there, everyone. Thank you for joining us today. Let me make sure my microphone's all next to my mouth here. That's great. My name is Marcia Butler. I'm the webinar director here at Advice Chaser, and I want to welcome you as you're coming in the webinar room. Before I introduce our guests and get started, I do need to do a little bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting, are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. We're thrilled to bring you today's educational presentation. Attendees are muted, but we do encourage you to ask questions using the chat box, and the presenter will answer those queries as we have time today. We do have a lot to get through. So put your questions in there, and if we have a chance to get to them, we will. If we don't have a chance to get to them, please leave your contact information and we'll reach out to you after today's event. I'd like to introduce you to our panelists today. Our moderator is Eric Maldonado. He is the owner and founder of Aquila Wealth Advisors, LLC in San Luis Obispo, California, established in 2017. Eric has over a decade of experience providing financial planning and investment advice. He is a fiduciary financial advisor and a fee-only financial advisor. That means that Eric and his team work under a fiduciary standard of care, putting their clients' interests first, and their compensation method is the most transparent and objective method available. Eric earned his MBA master's degree in financial planning from Indiana Wesleyan University and his bachelor's degree in business administration and finance from Cal Poly San Luis Obispo. In addition, Eric has designations of certified financial planner, practitioner, certified exit planning advisor, and certified kingdom advisor. Eric, why don't you come on the video and say hello to our folks today?
Hi, everyone. Looking forward to going over some good content on special needs trust, and feel free to chat and bring in your questions, and we'll get to them as we go and also at the end.
Thank you so much. Well, our speaker today is Matthew O'Leary, a founding partner of O'Leary Wallace LLP. Currently, Matthew practices trusts, estates, and elder law with an emphasis on special needs planning, conservatorships, and probate and trust litigation. Matthew has resided in the Central Coast since 2010. Before founding O'Leary Wallace, Matthew was an attorney at the estate planning law firm of Stephen K. Hall and Associates. He also worked for a boutique civil litigation law office in San Jose, California. Served as a law clerk for the Santa Clara County and Santa Cruz County District Attorney's offices, and held a judicial clerkship in the Family and Probate Division of the Sacramento County Superior Court. And Matthew, I'm really excited to have you back. This is an information-rich webinar, so I'm going to go ahead and turn the time over to you so we have as much time as possible for this topic.
Well, thank you for the introduction, and thank you, Eric, in advance for being the moderator today, and to Advice Chaser for having us. Yes, I am a estate planning attorney, and what is an attorney without a disclaimer? So here's my standard lawyer disclaimer, which is that I am going to do my very best to give you the best information that I can. However, your situation is fact dependent and truly unique. Please see an advisor of your own, or at the very least, please don't show up in court next week and say, well, O'Leary told me, blah, blah, blah. So I will do my very best to give you accurate and helpful information, and I hope that's what happens. So today's topic is about something that's very near and dear to my heart. We are talking about special needs planning for our loved ones with special needs and what their options are. and conservatorships. And why this is near and dear to my heart is because here's a picture of me and my two brothers. I'm on your right. My brother Ian is on your left. This is an older picture, of course, but Ian is in his mid-30s, and he is a former professional athlete and works in sales in the Bay Area. And then that is our little brother, Andrew, who's in the middle. And so Andrew is now 32. So Andrew was 14 in this picture. Andrew lives in the Sacramento area with my mother and father. And so I am 6 years older, 7 years older than him, and he has had an outstanding impact on my life in a really positive way. He's also why I know and why I like doing this area of work is because it is a job in unto itself. And all you folks that are dealing or helping loved ones or having loved ones at your home with special needs are true heroes, and I'm very proud of each one of you. So the first part of our discussion isn't about the court proceeding that lets you make decisions for someone. That's called a conservatorship in California, or it's called a guardianship in other jurisdictions outside of California. And that's what Andrew has. And so we'll talk about that later. But the first part that we're going to talk about now is the estate planning part. And that's the part that you and I, the loved one, gets to help our family member or a person with outside of a court plan. And I'll talk about why there's a lot of benefits to that. So every situation is different. And which of these situations fits you and your loved one the best remains to be seen, but we'll go through it step by step here. So a special needs trust is a term of art that you hear. Doesn't necessarily mean anything in and of itself, but what it means is it's a plan where, and if we could go back more, it's a plan where there is a trustee, and I'm going to use that word a lot today. A trustee means a manager. It means somebody who is put in charge of some property, and they hold property for a beneficiary. That's the person who gets the benefit of the stuff. And here, when we're talking about special needs trusts or special needs planning, our beneficiary that we're referencing is our loved one with special needs. Our trustee, that might be us, that might be the advisor of your choice. We'll talk about that later. That might be a successor family member or a sibling. But what makes it a special needs trust isn't that there's a beneficiary and a trustee, because all trusts and all these arrangements have to have that. What makes it a, quote, special needs trust is that the trust itself, the written document, has certain provisions in it that will make the money available for our loved one, the money that's in the trust, available for our loved one under certain restrictions. And we'll get into that. But what that really does is it allows our loved one to potentially qualify for certain financial needs-based public assistance, but still have funds available to supplement their other needs. So because it's a trust, it must have property. So it could be, and we'll talk about the type where the property comes later, but in general, there has to be property that's transferred into this situation. And then what makes the special needs trust work is that the terms in it are irrevocable. They can't be changed. And I'll get to some exceptions about that, but in general, once it's providing for our loved one, the trust is locked in place and is not to be changed. So why do we use these? Why is it a big deal? Why is it so helpful? There's a lot of public assistance programs that are entitlements, meaning that they're things that we get because we've paid into it, such as Social Security, or we get just because we're Americans and we're citizens. There's certain things that are entitlements. We're granted those, but there are many others that are needs-based. And so it's either needs-based because of a disability, or it's needs-based because of a financial need. And so this special needs trust is a tool to let us try to, again, get our loved one to qualify for some of these financial needs-based assistance, because to qualify for those things, there are strict limitations about the value of the amount of property that our loved one has. So in California, we have more liberal standards on who can qualify for these things than there are in other jurisdictions, but there are still hard cutoff lines in all jurisdictions about what means, okay, you actually need this public assistance, and you, on the other hand, have $1 too much and you don't need it yet. You don't qualify for it. You got to go through this whole process all over again. So it's a way for us to set up funds to supplement our loved one. So you might be saying, hey, all this talk about public assistance benefits makes me uncomfortable, or that's not us, or is there any other reasons why is that what it's all about? Yeah, that's a huge part of what it's all about. But there are certainly some other reasons that one would do a special needs trust for their loved one. When you're doing a special needs trust, you're creating a situation where somebody else is in charge of the funds for your loved one. And so because our loved one is now disconnected from the management of those funds, it can be a great protection from potential financial predators. It could also be great protection from making poor or imprudent decisions regarding money, stuff that kind of all of us maybe did when we were young, hopefully grew out of. But it's a way to make sure that a reputable, mature, trustworthy person is making decisions about what something can and should be spent on, avoiding our loved one from accidentally making a bad financial decision. Can also be protection from a marriage or former marriage that didn't work out. Funds that are held in a special needs trust for a beneficiary won't be part of that whole marital property dispute if that were ever to happen in that unfortunate situation.
All right, I'm going to go ahead and just shut this down. We've got some auto advance going on, and I just need to make sure that that's turned off. It looks like I've got it again. Here we go. Thank you for being patient. There we go.
So if you're handling the affairs of a loved one with special needs, you probably know or have experienced what might be an entitlement that they've got just because, and what or you might have seen other benefits that you had to go meet with, Department of Social Services if you're in California, or you went down to Social Security Administration to become a representative payee for SSI. So entitlements that don't go away, irrespective of how much money you have, are things like Social Security, Medicare, and I wrote in SSDI. That might have a different name where you're from, but in general, that's disability income. That is Social Security disability that was earned because somebody worked enough quarters. If that's what our loved one has, and that's the only thing that we're trying to preserve, we don't need any type of restrictive special needs trust for them, because they're going to have these things no matter what and no matter how much money they have available. But on the next slide, here we have some things that are in California available to those who have a financial need. These are things like Medi-Cal, which is the California version of Medicaid. That's the state assistance for medical care. Section 8 is what we call it in California regarding housing, but there's typically some form of housing assistance in every jurisdiction. CalFresh is the food assistance program here in our area. In your area, it's going to be called something else, but it's still available to folks based on their financial need. And then the big one that a lot of folks have is the supplemental security income. That's the SSI. When our loved one or when anyone doesn't have an income, they're not paying into Social Security. And so the government's fix for that, for those people that have disabilities or have a need where they're not able to work or haven't worked, there's a payment that they can receive that's up to a little more than $1,000 a month, SSI, Supplemental Security Income. They only get that if their income is such that it doesn't replace that amount of money. So those are some of the big things that folks are looking to protect or preserve if their loved one would otherwise be entitled to them. I briefly mentioned, kind of how it works. It has certain language, but in its like functionality, how does the special needs trust work? It's got this, again, they're just words on a piece of paper, but that makes it totally legitimate and legally enforceable. And they say that our beneficiary does not have the ability to say, give me the money from my trust right now. And then there's restrictions. In some states, the restrictions have to be mandatory. The trustee shall not distribute funds from this trust if they are otherwise covered by something like Medicaid, Medi-Cal here. In some jurisdictions, California is one of them, it can be discretionary, but the point is the same. It has to say the trustee should not distribute funds to these certain things: housing, food, cash on hand, if it's something that's being provided for otherwise in certain government assistance. And so the beneficiary can't demand that property that it be distributed to her, and the beneficiary can't terminate the trust. They can't say, I've had enough of this and all these rules and regulations. Go ahead and just give me the money. So instead, we're putting the burden on our trustee to come up with what is an appropriate thing to pay for and what is not. And that is a lifelong job that does require some real thought and real knowledge of the law. But your trustee has to look at your loved one and say, I want to make distribution to you because this will improve your life, or I want to make distribution to you because this is something that you may not realize you need, but you really need. But I want to do it in such a way that it gives you, quote unquote, the best of both worlds. I want you to still be able to have that essential service that you need, like Medicaid, housing assistance, etc. But I also know that you need a therapy that's not being provided, or I know that you need a hospital bed that Medicaid is not going to pay for. I know that you need assistance, an additional caregiver who's going to be with you all the time because your epilepsy is such that you could fall and hurt yourself. There's a lot of these things that certainly are not provided for, that the trustee has to do a balancing act and decide what can we afford, what can we pay towards that won't jeopardize benefits, and what can we pay for that will actually replace a benefit if it's in one of those jurisdictions like California. What can we pay for that will replace a benefit because it's just better for the beneficiary that way? So some rules of thumb, though, is that the trustee shall not, almost universally, the rule is it shall not just say, here's some cash, have a good time. And in that same way, they shall not, and this one gets frustrating for folks, they shall not reimburse the beneficiary directly for purchases that the beneficiary makes. So I do talk to clients who are on the other side of this. They have a trust for them, maybe a special needs trust, and they say, well, it's supposed to pay for my travel or my entertainment or my therapy. Last year, I rode the train to Portland to see my daughter, and then we went out to eat there, and then I came back home on the train, and that was expensive. It cost me $900 or something to that effect. And I say, they're not going to reimburse that. That's the same as just handing you cash if they're not careful. So they're not doing their job if they do that. But had my client in that instance had a good relationship with the trustee and communicated in advance, she could have said, I'd like to go visit my daughter in Portland. There's plenty of money in my special needs trust for that type of thing. Would you please buy me a ticket to Portland? Would you please pay for, this caregiver to accompany me? And those are perfectly appropriate distributions the beneficiary could have done, or the trustee could have done, had it been done in the right order. So those are the type of things to be careful of. Regarding housing assistance, this is quite technical and it's also quite specific to California, but I kept this in here because I do want you to know the type of detail that your trustee has to navigate when they're thinking about distributions for things like housing. So a common structure for my clients when we do estate plans for our loved one is to potentially have a housing option for their loved one who has special needs. Maybe it's an apartment or a condo that they've purchased. Maybe it's their own home where the person lives, and they want to make sure that that home or that apartment or that condo remains available. So in those types of situations, a special needs trust can be perfect, because had it just gone to our beneficiary, that's a benefit that they could lose. So here, if you make a distribution to a special needs trust recipient and it's in an improper way, Department of Housing is going to look at that transfer and say, okay, that means that that money was available to our special needs loved one, and therefore they don't get their housing. And sometimes that housing option is the only solution that a person has, and it's very difficult to recover it if it's lost. So there are different types of special needs trusts, or different ways that they are set up. And one of them is maybe the most obvious, but that is the idea that from page 1 to the last page, this is a special needs trust. It is a standalone special needs trust. It is created start to finish as a special needs trust for our specific loved one, or it could be for a couple of loved ones, but typically it is for a single beneficiary. And that single beneficiary standalone special needs trust could be set up actually by the beneficiary who has special needs, so long as they have, of course, the ability to do that kind of thing. Andrew, my brother, certainly does not have that ability, but lots of other folks do. So I could, if I was the special needs person, I could create it for myself and say, here are some rules about property that's going to be held for me. And then transfers to that first party special needs trust are not going to say, they're not going to disqualify me for benefits. That first party special needs trust could also have been set up by my parent on my behalf or my child on my behalf. But again, it's as if I am literally setting it up just for me. And the nice thing about that is I get to pick the trustee because I'm setting it up, or my family is. I'm hopefully making some decisions because if I'm involved or my family's involved, they know me really well, so they're making decisions that are in my best interest. And then as property goes into it, again, there's not a penalty for doing that, so people could still qualify for financial needs-based benefits. The downside, or one of them, is that trust has to have certain provisions in it about whether the funds get used to pay back money that was paid by the state on your behalf. A third party standalone special needs trust is one that is done by somebody else. That's the third party. If I'm the person with special needs, Eric, the moderator, could set up the trust for me, and it could say, here's my millions and millions of dollars, is what Eric would say. Millions and millions of dollars set aside for Matt and his benefit. And here are a bunch of special needs trust terms. And the big upside of that is it can be more flexible, because he's not doing it under certain federal regulations that allow for a special needs trust to not be counted. He's doing it with a much broader vision. And at the same time, he can also not have that payback provision that folks typically want to avoid. So he is creating it for me with his money, not my money.
Matt, we have a question. If someone wanted to create like a consistent monthly like expense purchase, does that have to go directly to whatever that expense is, or can it? That's pretty much the only way, right? If there's a consistent monthly need of money from the special needs trust.
Yeah. If they're gonna say, hey, this person, every month they come up short in their checking account, they need an extra $500 every month to just be transferred in. That's the equivalent of income, and in some ways that would be fine. But for something like if that person depends on SSI, that supplemental security income for folks that don't have income otherwise, that all that will do is it will delete the SSI of the same amount that you're distributing in. So if the better way usually for management in that situation is to say, this person comes up $500 short every month because they have a gym membership, they pay for a certain thing on subscription, they have an internet and TV cost, and they like to give to their church. And so you can start making those gifts or those payments instead, straight from the trust, auto. Nobody has to think about it much. It's not wasting anyone's time to set it up, but it's a way to provide for those gaps where those needs, fill those gaps, the budget shortfall, without just giving money directly to them.
Got it. It's helpful.
Yeah. So regarding those first party special needs trusts, there's court approved ones and there's non-court approved ones. This gets pretty technical. There is such a thing as a seed trust, which is allowed, which sometimes means that somebody's setting it up with essentially no money. I did point out that first party special needs trust is funded with the special needs person's money. But in some instances, that's just a tiny bit of money because there's other money that's coming later, maybe through a settlement or an inheritance or some other type of gift. But in the interim, it's being set up with a nominal amount of money. But this is the federal regulations that allow for this type of thing. I get people sometimes who feel uncomfortable because they think something here that's being done is somehow like a trick, like that this is a theft, or this is like, well, this is only working because we're cheating or we're doing something. No. This is done directly because there's federal and state law that say you can do this. You do it in this way. All of this is done very much above board, very much legally. There's federal regulations. There's going to be state regulations in your state regarding how it's implemented. And so that's why these provisions are included in here for your review now or later. So when I do these presentations to families is usually the situation where I'm doing them and we're talking about their loved one, often maybe a minor or a new adult. And I always say, this is probably the one that's most applicable to you here in the room. And the reason is that if you're a parent of a special needs person, you are probably not giving them your money, right? You're probably saying, I'm providing for my child or my loved one or whomever it is. And I'm just thinking about, gosh, what if it wasn't me? What if something happened to me? And now all of a sudden, maybe my loved one, my child, let's say, for example, is the natural heir to my estate. Then what would happen? So a lot of times we're talking about planning for as if we're talking about, gobs of money, but the reality is this our special needs person doesn't have any money. It's just thinking about if something happened to us, now all of a sudden they would have money, whether that's life insurance, retirement accounts, whatever the case might be. So I don't know that if you Google special needs subtrust, you'll find any results. It's just what I refer to it as. But that is the idea that you in your own estate plan, if you have one, great, you may have already done this. If you don't have one, talk to the advisor of your choice. But in your own estate plan, you create a trust, or it could be done through a will, but typically a trust. And it says, our stuff is ours. Our loved one with special needs has nothing to do with it during our life. We can spend it, we can use it however we want. We're totally in charge. But if something happens to me or to us, and our loved one is now a beneficiary, they would stand to gain from us because we're now gone. Our financial legacy will pass to them. Now, all of a sudden, according to the document that we have, that we did, that's amendable and changeable and revocable, now all of a sudden, the share that's set apart for our loved one with special needs now has these special needs trust provisions in it. So people will come in and see me and they'll say, I have a 7-year-old, I want to do a special needs trust for them. And we start talking about it and it becomes apparent that they're not trying to give their 7-year-old, set aside money for their 7-year-old today. They're just thinking about what if something happened. And so in those cases, almost every time, we're creating a trust inside our trust that says, if something happened, this triggers, and now there's going to be these special needs trust terms that are going to protect our loved one.
And Matt, that would provide a new manager or a new trustee.
Yeah, so it would say that if I'm in charge of my trust while I'm alive, and then if I die, suddenly an advisor, you know, Eric, I know that's not you, but let's say that was you, that type of advisor, you would now jump in and be the new manager of what was once mine, that's being held for the benefit of my child. And I get to pick all that in advance. And what's nice here is that it says the terms of this trust can be changed at any time by the settlor up until the time I die. And at that time, the settlor is the person who creates a trust. It's also called a trustor or a grantor. It all means the same thing, but it's the person who's creating this trust. When I die, all of a sudden that provision is irrevocable, and can't be changed really. And now that's what makes it a special needs trust and makes the assets that are there unavailable for our loved one. But up until then, I can change it every day. So I could have Eric for this year, and then next year I move to a different state, and now it's time for a different advisor. Or 20 years pass, and my initial choice to help my loved one is retired, moved away, out of the industry, dead. I can have someone else in my documents, and I'm not stuck with what I chose way back when.
Got it.
So it's still managed by a trustee. Some of the things to think about when you're picking a trustee, which again, day-to-day manager, is you do need somebody who is capable, not necessarily of knowing off the top of their head all the rules that regard a special needs trust or taxes or what type of distributions, but you need to be picking someone who is capable of recognizing there might be an issue. And then somebody who is a fiduciary, going to uphold all the fiduciary duties. A fiduciary, like Eric is for his clients, is someone who has the highest duties of loyalty, good faith, fair dealing, in connection with who they're holding something for. So they can never make a decision that is in their best interest, the trustee. They can't even make a decision that's in equal best interest. Their decision has to be what is for the beneficiary's best interest. And then my interests are always subservient to that. So that can be a professional for you if there's not a loved one or a person in your life that you think is a good choice. Professionals are in California, there's a whole section of the Department of Consumer Affairs that license individuals to be a trustee. But everywhere and more traditionally, there are banks, there are trust companies that will all hold these funds for the benefit of a loved one who has special needs. And they have to be somebody who understands that, or will go figure out what the impact is of making distributions so that they are careful to not make the wrong type of distributions. The beneficiary in this situation can never be the trustee. That may have been clear from what I've said earlier, maybe it wasn't, but let that be clear now, that our loved one is never the one who's in charge of making these decisions. Their job is the trustee's job is to make the assets productive. So they are to be careful with it. But I do see clients from time to time who come in and they say, okay, great, and I've got this special needs trust, and here it is, and it's a relatively substantial chunk of money, and it's just sitting there in a bank account. And I say, why? And they say, well, you never know. We might need it. And I just don't want any impediment to accessing it. And that is, on the one hand, prudent. But if we're too focused on that, we can actually be imprudent by costing the beneficiary growth, earnings, appreciation in a way that you would not appreciate if that was your financial advisor doing it. Oh, it's just all going to sit here in cash. So the person does have the job to make the assets productive. So this is a planning tool that for folks that have a loved one with special needs. Are there reasons to not do it? Sure, of course. There is the cost of establishing something like this. Attorney's fees range wildly, but a standalone special needs trust costs something. Doing a trust or a will that creates a special needs trust if something happens to you, that might be a different cost. But either one of those things would very likely, cost you $1, $2, $3, $4,000, depending on what type of attorney you see, maybe more. So there are initiation costs to set something up. And then once a special needs trust actually exists, so not that subtrust I mentioned that exists someday when you're gone, but that standalone one or that third party one, or after you're dead and gone, and now your special needs trust provisions inside your own plan are in effect. Once the trust exists and has property, it has to file a tax return. It's called a fiduciary 1041 throughout the country. And there's a state return as well. So it will, you'll have to pay for an accountant, or you'll have to do that on your own. And then if if you didn't distribute income, it's possible that you have a higher tax rate in those trust assets. And then there's a trustee who is managing it. And unless it's somebody doing it out of the goodness of their heart, which may be great or may actually be bad, that trustee might charge for their job as well. So there are definitely some financial costs that might be unavoidable. And then there's the restrictions. So some folks choose to not do this type of planning because they just don't like the idea that their beneficiary is not going to get the full use or the full availability of what they set aside for them. They would say, I don't think, we have enough funds. This is a great reason to say it. You say, I have plenty of funds, and the governmental benefits aren't going to really serve a purpose here. Or you just say, I don't really like the idea that somebody else is in charge of the loved one's share. I want them to have their own funds, despite, and that's the decision that you have to make. There's not any condemnation making that decision. So this is all regarding planning that what we just talked about is regarding planning for a loved one, regarding finances, to be able to set aside funds to supplement their needs and still allow for qualifying for other types of support if it's available. Second part of this presentation is conservatorship or guardianship where you live potentially, and its alternatives. But this is more geared to management and decision making for a loved one, as opposed to just who's writing checks and what type of expenses are going to get paid. So in California, conservatorship is a court case where a judge is appointing someone to essentially step into the shoes of a person that the court has decided cannot make their own decisions for their own care and support, or can't manage their own finances. I highlighted it as not a guardianship because in California, we call the proceeding for children to step into the shoes of what it would be a parent and make parental decisions for a child. We call that guardianship out here. But I know in lots of other jurisdictions, a conservatorship is called a guardianship. So don't get that confused if you look at this later. California guardianships are for kids, conservatorships are for adults. So when you ask to be a conservator out here in California, you are saying, I have to make the legal decisions for this person. And one of the things that the California court, and probably the court where you are, wants to see is they want to say, why do we have to do this? Why can't you just go do this on your own? We've got plenty of other things to do. And so you have to explain why the other alternatives to a conservatorship aren't good enough. And that's a good exercise to do, because if there are other alternatives that are good enough, let's try to not have a conservatorship. So some of these alternatives are, particularly for our adults who can understand and can communicate in some form, it's just voluntary acceptance of services. Somebody where they just say, yes, please help me, or would you please help me? In California, we have something called the regional center, kind of a network. There are these agencies that are receiving funds from the state, and they're saying, we will service all the folks who qualify with certain disabilities who are in this area. In my county where I practice, it's called Tri-Counties Regional Center. They service our county, Santa Barbara County, Ventura County, and they will, they have caseworkers, they help with benefits, they do caregiving, they do housing, they do all these different things. And it's free in the essence of it's public assistance that's already available. And then if this is the situation that fits your loved one, you know, a huge benefit of this is that this means our loved one has a freedom and autonomy. They get to have assistance, but they don't have somebody literally taking away their ability to make any decision. The cons of this and why it might not be applicable for you and your loved one is that there's no protection from predators. There's no protection from creditors either. There's no ability for anybody to step into the shoes of our loved one and make decisions for them. And there's no ability to overrule their decisions. So if they're making certain decisions that just aren't the most prudent, there's nobody that can say, I'm sorry, we're not going to do it that way. And there's no decision that they don't have capacity to make a decision on their own. So if they make a really bad decision tomorrow, that's totally fine because they have every right to, just like you do. So the second option that the California court asked for and that you should think about no matter where you are is, okay, could we do this with written documents? Could we do this with a power of attorney? Or the next one is with a healthcare directive. And the idea in both of those is our special needs person is saying, I'm going to nominate someone else to be able to step into my shoes and speak on my behalf. So that's inexpensive. That allows, again, more freedom and autonomy for our loved one, our special needs adult, while still allowing them to have somebody who could step in and help. The downside of that is that, again, there's not necessarily as much protection from some sort of predatory situation. And it also is not, it's still not going to, the special needs person is still going to have the right to be able to usurp the agent. They can say, no, I know my agent wants to pay that bill, but I've decided we're not going to. Or I know my agent has told me we're not going to spend all the money in the account, but I disagree. We are going to spend all the money in the account. So it doesn't take away our special needs loved one's ability to make decisions. Healthcare is similar. It doesn't take away our special needs trust or special need beneficiaries' ability to make medical decisions. You know, my child just had to get a blood draw, and he's underage, so we get to make that decision. Would he have made that decision on his own? No. Would he have ripped the needle out and stabbed somebody with it if he wasn't being restrained? Yes. So there are cases where our loved one needs a certain medical treatment or a certain decision made, and they don't want to. And so the power, if all we have is a healthcare directive or a healthcare power of attorney, then they're going to be able to speak for themselves and say, no, we're not going to do that treatment, even if it's in their best interest. For banking, there's alternatives here. So when we're talking about how are we going to help with our loved one's financial affairs, and it's not a power of attorney, there's options like a joint bank account, or there's also another option in California called an ABLE account, where you have funds in our joint account. We have perhaps my name is on the account with my special needs loved one. We're on the account together. That means we can both transact and do business. And that means I can help by paying bills, or I can make deposits easily. And that's a very inexpensive way to go. The ABLE account is a bank where either it's in the special needs beneficiary's name, or if it's someone like Andrew, who's, again, we're talking about adults who can understand and communicate, which Andrew does not verbally communicate. So, but an ABLE account, our loved one can create an ABLE account in their name, or someone can be their representative on the ABLE account. They can put money into it, and it won't be counted against them for the purposes of qualifying for benefits, but it's funds that they can take out and use for their needs when they need it. It can get confusing though, and that's one of the downsides of just trying to do this through joint banking. It can be confusing about who owns it, and it certainly doesn't stop our loved one from making decisions that might not be in their best interest. So we just went over the topic of trust, but again, the trusts are for financial management. And if our loved one could have a trust instead, the court would much prefer to see that than to name someone to step into our loved one's shoes and be their financial decision maker.
Matt, on that topic, you had mentioned before, a trustee has a responsibility to make sure the assets are productive in the trust.
Yeah.
How do they go about doing that?
Say that again.
Oh, how do they go about doing that? Like how do they make sure they're productive in the right way? There's probably quite a bit of discretion. Do they have help with that?
Yes, that's a great question. No one's ever, when I advise trustees, so not the family setting it up, but I'm advising a trustee handling assets. The job is to be a prudent investor is the standard. The prudent investor standard is the rule. And the best way to make sure that you're following the prudent investor rule is to have a professional who's helping you, telling you, this is a good system, this is the right decision, this is aggressive. So if I have a client who has a reputable, licensed investment advisor involved, I feel much better about that situation, because it's very hard for somebody to complain and say, hey, you didn't do a good enough job managing this, when you say, well, what are you talking about? I use this professional, they built this model for me, they told me, how long do we want this money to last? Okay, here's what we got to do. So even if that's just a financial planning meeting that you're paying for by the hour, that type of additional help for your trustee is crucial to make sure that they're doing their job. The other kind of thing is just a feeling, a sense, like if you said, if this was my money and I really wanted to make sure it lasted, would I do this with it? And if the answer would make the person uncomfortable, what's being done with it, then it's probably not prudent. It's probably not reasonably prudent. So it is a vague standard, but it's vague for a reason. Every circumstance is different. Some folks have very high needs and expensive needs, and so money's going to be spent a different way than a person who doesn't.
Got it.
So those decisions were all those alternatives were all for folks who can understand and communicate regarding their desires. They can make their own decisions. So when I say understand and communicate, what does that mean? I don't know. I think you probably know, though. That's kind of my short answer. You probably know whether your special needs loved one is able to understand and communicate well enough to make decisions for himself or herself, and therefore use one of those other alternatives that they're voluntarily getting into. So in California, I put in here the standard for creating a estate planning document to be reviewed later if you'd like. And then in the next slide, I put in the standard for a contractual, the standard for contractual capacity, which is saying that I have the legal ability to enter into an agreement. So the estate planning standard would be for something like a power of attorney potentially, or a will. That contractual capacity would be higher, and it would be something like, do I have the ability to enter into a trust? But either way, these are standards that are set forth in California probate code, and the default rule in all these circumstances is that a person does have the ability to enter into these unless they don't. And so when we're talking about our loved one, that's why we're potentially seeking a conservatorship, because the standard says you don't get to keep making decisions for your special needs person just because you always have, or just because you did when they were a child. Once they're an adult, the default rule is they have their own now ability to make all their own decisions. And so that's why we have to seek and sometimes get these court orders that say, wait a minute, that's not safe, or that's not good, or that's not going to do enough. So these are alternatives. The next alternatives are for folks that they can't understand and communicate for themselves, but can we still avoid court proceeding like a conservatorship anyway? So there is a very helpful financial solution on the finances side for folks that can't communicate and understand enough for themselves, and that is being a representative payee for Social Security or veteran benefits. That's my little brother Andrew. He does not have a conservatorship over his money because my parents are his representative payee. And so they've gone to Social Security and they signed up, and they're beholden to Social Security about how they spend that money. but they get to manage his SSI that comes in, and they don't need any type of estate planning or court order to let him do it. For medical decisions, however, there's no legally enforceable alternative to a court proceeding. There's no representative payee solution, at least in California. I have my own creative ideas about what we should do as a society to try to solve that problem, but but in California, there's not. So being a parent, let's say, being my Andrew's parents, that probably works in practice some of the time. Maybe it works almost all the time, but it's not legally enforceable. So if Andrew goes in for medical care, at the end of the day, if my parents don't have a conservatorship, they can't speak for him, even though he can't speak for himself.
Matt, I just wanted to break in here. I know that we're coming to the end of our scheduled time, and I do want to tell our attendees that we probably won't have time for question and answers, and I do want to finish up and give people their day back at the top of the hour. So Matthew, if we can just go ahead and work on that, and then we can close here at the top of the hour.
And we are getting near the end here because it starts to get a bit technical. But one thing I do want to make sure we touch on is this difference that I keep alluding to between a conservator of the person, a conservator of the estate. A conservator of the person is making legal decisions about a person, where they go to the doctor, where they live, what school they go to, what happens at their, whether they see this therapist or that. Conservator of the estate is who's handling money. And so if we did good special needs trust planning, we hopefully don't even have a conservatorship of an estate issue. But that is a financial aspect of a court proceeding. And it's a tough one, and it's definitely worth avoiding if we can, just having a conservator of a person. So in California, this type of proceeding all starts with a petition to the court, essentially like a motion or a request that says, I need to be appointed, or this person needs to be appointed for this other person, who we in California call the conservatee, or the proposed conservatee at the beginning. And then they have to make, the person who's requesting it has to ask for what powers they want. Do they want to be able to make all decisions? Do they want to make all the decisions that are the default plus some? Or do they want to make less decisions, certain aspects that they don't have to decide on? In California also, we have something called a limited conservatorship versus full. A limited conservatorship is for folks that are developmentally disabled, and it's designed to have some type of a greater amount of autonomy for someone who's labeled developmentally disabled, so that they can have help in some areas, but perhaps not in all areas. They still have maintained some amount of their own decision making. A full conservatorship, there's not the gray areas. There's just saying you can make all the decisions on behalf of the conservatee. So my little brother Andrew is developmentally disabled, but he is non-ambulatory. He doesn't verbally communicate. And so there's not a concern about his autonomy versus who gets to make decisions. He has a full conservatorship. So the duties are broad. They are regarding medical treatment. They are making decisions when medical treatment, even if the person objects, if the person says, no way, you may not take my blood draw, in at least in theory, the conservators can be granted power to say, sorry, it doesn't matter that you don't want to do it. We are going to do it. The conservator then has a number of responsibilities, including determining what level of care the loved one needs, the special needs person needs. They have to submit a form even that says, I've thought about it and this is what it should be once they're appointed. They have to make decisions about where to live, and if they actually want to move the special needs person from where they presently live, they're supposed to tell the court before they do it, and then they're supposed to tell the court after they did it. It's this double step to make sure that we're not just letting folks run into the home and yank somebody out and stick them wherever they feel like is most necessary. We have these extra steps of protection to make sure that the conservatees' preferences and their what they're used to is respected. In these estate proceedings, so these are the expensive ones, the messy ones, when we're managing finances for somebody else in a court proceeding. If you have been involved in that, you certainly know what that's like and how slow and expensive that is. If you haven't, I hope you don't ever have to. The court though has this responsibility to make sure that somebody's needs are being met and that they're not being taken advantage of. So with that court oversight though comes a great amount of time and money cost, just because if it's in a court, it's going to be slow and expensive. Let's go to the next one after this, Marcia, if you don't mind. So how does this, what does this process cost? In California, if you factor in the attorney's fees part, the sky's the limit, right? Britney Spears had famously, was recently in a conservatorship, but until recently had been under conservatorship. I don't know what the fees were in that matter, but I promise they were more than $1 million. It can be very expensive and time intensive and technical. And so the fees just mount up. I had very little, but a slight connection to another conservatorship that involved one of William Randolph Hearst's grandchildren was conserved here in San Luis Obispo County. And so that administration, that conservatorship matter was extremely expensive. In a matter where it's family seeking to establish a conservatorship for their loved one, it's much more, it can be much more fixed. We can have a much better idea of how much it's going to cost before it happens. I'm able to tell my clients, like within a couple $100 usually, what it's going to cost. And I tell them that at the very first meeting. And so that 6 months later, when it's finally done, we're usually within, again, a couple $100. We're able to give a very accurate estimate on what it's going to cost. So ask for that in advance if you're going to see an attorney, and it's not a contested situation. There's nobody fighting about it. Ask in advance and try to hold them to that, frankly. There are other costs in California that are unavoidable, and there probably are where you are too. There's a filing fee to get the process started. There's postage, there's a court investigator's fee, there's other e-filing fees, and then there's actually fees for a court-appointed attorney. Thanks to Britney Spears, every single person now in California that's involved in a conservatorship gets an attorney for them if they don't already have one. And if that person has money to pay it, then those fees are going to come out of that person's pocket as well. So it's definitely, get again a good estimate from your advisor on what all these are so that you go into it with eyes wide open. So how long, once it's granted, how long does a conservatorship last? It lasts forever. It lasts until the conservatee passes away. But is a conservator appointed forever? Well, no, it's not. Slavery's been abolished. They don't have to be the conservator forever. They can resign. Of course, if they pass away, they're no longer conservator, or the court might remove them if they're doing something they shouldn't. So the appointment of a conservator is designed to be indefinite, but certainly doesn't mean that it lasts forever. When the conservatorship estate runs out of money, that's the conservatorship ends in that situation too. Or if the conservatee gets, improves or reaches a situation where he doesn't or she doesn't need any help, she doesn't need someone to step in and make all of the legal decisions for them, then the conservatorship can end or be terminated in that situation as well. And I've had that situation happen. So in general, though, it's an appointment for the person's entire life. Folks, this was a lot of detail and that we tried to breeze through. Thanks for bearing with us. And Eric, do we have time for one if we have any questions?
Good job, Matt. Thanks, everyone. It was regarding the blanking on it now. I thought it was about the I forget what it was now.
No problem.
I do have a question that just came in.
Yeah, sure.
Can you say what's most common for special needs families, the first or the third party trust, or is it just dependent?
It depends on the situation, but it's probably more common to be a third party or special needs subtrust is a third party trust essentially, but it's a trust that you're doing on your own as opposed to a first party where it's being done for the person because they have funds or because there's some incident where they're getting funds. So when there's like an accident settlement, that might be a first party special needs trust. If the person had inherited money, they might, but often when we're doing special needs planning, we're not planning for folks that earn tons and tons of money at some point. We're usually thinking about how do we preserve them and you make sure that we maximize their quality of life, both now and for as long as possible.
I remember, Matt, it was on the topic of the power. There's no document in California that helps someone with the legal matters of healthcare.
That is for someone who's, yes. So if someone's not able to communicate and understand a document, essentially the person's doesn't have capacity to sign a healthcare directive, that there's not some other alternative to step in and make decisions for them just by, de facto. Like there's not like the representative payee process is one that Social Security created and said it'd be too hard if everyone had to have a court proceeding if they weren't able to handle their own affairs. You can just come to us, show us why you should be the representative payee, and in general, we'll say, okay, fine, we'll grant that for you. And you don't need a court proceeding to show that you should be able to do that. There's not an equivalent, at least in California, I don't think anywhere else, where we do that for healthcare. We don't say, hey, just because you're the parent or just because you're the most involved, you should just automatically get to make healthcare decisions for your special needs loved one. If your special needs loved one's not able to nominate you to say, I want you to do it for me, it doesn't have the capacity to do that. The only alternative, unfortunately, then is a court proceeding to be able to do that.
Got it.
Well,
Thank you.
Well, thank you, Eric and Matt. Thank you so much for our attendees for being here. We know this was quite a information heavy webinar. We appreciate you spending your time with us today to make sure you're getting informed. Look to an email soon with a link to the replay of this event, and you're welcome to share that replay with friends and family. And we want to also thank the organizations that have made this webinar possible today. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Well, once again from Advice Chaser, thank you so much for coming, and we'll see you at another webinar soon. Goodbye, everyone.
Bye.
Bye.